As a court, please, my lord, we apologize for the late start. We don't have an interpreter at the moment, my lord. Mr. Jonas is busy arranging for an interpreter in another court.
I see.
And he's not yet here.
Okay.
Maybe we can just, I don't know whether we're going to wait for him. He said it will be about 5 minutes long. I think he should be here any moment.
All right. Yes.
Yes, my lord. Yesterday, when we adjourned, there was a debate as to whether Mr. Ramosele can use photos that were obtained pursuant to an investigation in the second docket, First Lawyers Cast 3751 of 2019. We raised an objection. We subsequently had a conference with the defense regarding those photos, and Mr. Ramosele has indicated that he will no longer be using those photos subject to confirmation by him. However, my lord, we just want to sound a warning to my colleagues regarding the use of statements either in this docket 63610 of 2014 or in 3751 of 2019. There's a tendency to quote passages of statements in either of the dockets, but until now, out of this main docket, 63610 of 2014, and invite Brigadier Gininda to comment on what those witnesses are saying. We submit, my lord, that that is improper. You cannot use, as we've objected yesterday when Mr. Ramosele was quoting passages from some statements and eliciting the comments of Brigadier Gininda. You cannot use inadmissible evidence in cross-examination. The only way, my lord, to use such statements is if the defense signal their intention to call those witnesses. But unless they do that, my lord, that remains hearsay evidence. And in this regard, we just want to briefly refer to the Handbook of Detroit Criminal Procedure under cross-examination on page 22 to 54, when it deals with cross-examination and re-examination of witnesses. He writes the following regarding the use of inadmissible evidence, and he says, cross-examination based on inadmissible evidence is not permitted. And he then lists the categories of such inadmissible evidence, and amongst those categories he refers to an unproven document which the witness also cannot prove. And he quotes then the case of Howard versus Decker, Vetcop and Agencies, and Forwest Estate Pty Ltd and De Sousa, 1971, volume 3, essay 937T at 948E to H. We had a look at that case. It's an old case, 1971 case, and it's the decision of the then Transvaal Provincial Division. It was a civil case, but the principles are still equally applicable. And in the heading, it says, where the party against whom a private document, in this case a private document, was applicable, but the the principles are equally applicable to a criminal case. Where the party against whom a private document, in this case a deed of sale, not complying with certain requirements, is sought to be relied on, has neither been admitted nor its authenticity proven, nor that the contents thereof are correct. Its contents cannot be used either as evidence or for the purpose of cross-examination. And proving the authenticity thereof, my lord, entails calling the deponent of that document to identify it. And in this instance, paragraph G, even though it was a private document, the court referred to in paragraph G, and we quote, the law in relation to the proof of private document is that the document must be identified by a witness who is either, one, the writer or signatory thereof, or secondly, the attesting witness, or thirdly, the person in whose lawful custody the document is, fourthly, the person who found it in the possession of the opposing party, and fifthly, a handwriting expert, unless the document is one which proves itself, that is either produced under a discovery order or may be judicially noticed by the court, or is one which may be handed in from the bar, or is produced under a subpoena, duces tecum, or is an affidavit in interlocutory proceedings, or is admitted by the opposing party. So in other words, my lord, the rules of admissibility of a document must first be satisfied before a document can be used in cross-examination. And this applies to all the statements in this matter, as well as the statements that were made pursuant to an investigation in Foslores Cast 3751 of 2019. We don't want to disturb the flow of the proceedings by standing up and objecting every time. Hence, my lord, we just felt that we just need to bring this to the attention of my colleagues. Thank you.
Yes, Mr. Ramosele.
As the court pleases, my lord, I note the submission by my learned colleague, my lord. However, I cannot respond at this stage, my lord, because I did not go and prepare for that. I'm busy preparing for the application. If I need to respond, my lord, it will have to be tomorrow.
I don't understand. Yesterday we said you should prepare.
No.
Both of you. Or
No.
not you, both, all of you.
No, the court said we can either discuss it amongst ourselves or prepare. Or prepare.
Yeah, that's what I said.
Yes, or prepare, not discuss and prepare.
How do you prepare without discussing?
No, the discussion was whether is it necessary to prepare for this argument pending that I'm going to use the statements or not. But once we decided that I'm not going to pursue that line of questioning using those photos, we then decided amongst ourselves that preparation is no longer necessary.
I see.
Yes.
So you're saying, I don't want to prejudice your client. Did you want to use that information? Let's start there.
It is not material for my cross-examination.
Well, why did you bring it to court and...
My lord, I specifically stated why I brought that information to court.
Oh, okay, fine. What was the reason, by the way?
My lord will recall. I don't know which witness was it during the main trial. Reference was kept on mention of the park, the left 20 meters.
Yes.
And the court asked my learned colleague, Mr. Baloyi, that it's imperative that the court has sight of the photos of the park and the surroundings. And in light thereof, my lord, I think the following day, Mr. Baloyi came and finished all of us with disclosure regarding those photos and the album and the statement of the person that took those photos. However, my lord, that was not pursued thereafter, and the court never inquired further. But then As I was preparing, my lord, like I said, I came across those photos, and it was just to remind the court that the court once asked for these photos. Is it also necessary now to have that witness come and testify to orientate the court as to the park that was searched by the community, by the first responders, where it is alleged that the intruders ran, which is 200 meters away from the scene? That was the purpose, ma'am.
Yeah, it's obvious the court wanted to know if there were photographs of the scene. And the answer then, because it was silent, I thought no photos were taken.
It is unfortunate, but because we were finished, my lord, with the photos the following day, after the court.
And you never brought that to the attention
it was never brought to the attention of the court.
Now the question is, do you want to use them, sir?
No, I'm not going to utilize them, my lord.
Because I don't want it to be said
No, it won't
that you are being refused, and your client is being refused an opportunity to use those photos, which were supposed to be part of his defense.
Yes.
Are you with me?
I am, my lord.
Yeah.
And I did discuss it with him this morning to say I'm not going to utilize the photos because this was the context within which I was bringing it to the attention of the court, and he is well versed, my lord, that I'm not going to use those photos anymore.
Let's hear your colleagues, Mr. Musi.
Thank you, my lord. The prescription, which is of a blanket nature, my lord, that the state seeks to impose on the defense with regard to the usage of certain statements, tends to be unlawful, and from where I'm standing, it's a bit rational because it does not take into account the provisions of the Law of Evidence Amendment Act number 45 of 1988, which amongst others stipulates that information that is contained in a document or information that is contained in a statement may be admitted on a provisional basis, where the person who seeks to use that information undertakes to call the person whose property value the content of such statement lies. So the person who wants to use that statement can simply make an application to court and say, my lord, may I please be granted the leave to use the content of the statement, because later on then I will call the person upon upon whose credibility the content of this document lies. There's nothing wrong with that, my lord. That is just point number one. Point number two, my lord, is the state makes a disclosure. Upon investigation, or let me actually start it here. The state receives a complaint that is investigated by police. The police go out and take statements from certain witnesses. Then the matter gets brought to court and there's a trial such as this one. And the state makes a disclosure. In the process, circumstances had arisen in these courts, and in certain circumstances may also arise. I've also done this as well. Then you go to the list of state witnesses. Amongst the list of state witnesses is a particular Mr. X, maybe he's witness number 5. And then they call the first witness, the state calls his first witness, and then the process of cross-examining that witness, who's witness number 1, and then you refer to the statement of witness number 5, who's also mentioned in the list of state witnesses. For instance, you come and say, Mr. Witness of Brigadier Gininda, the state is going to call Mr. X, who's witness number 5, who's going to say, amongst others, this and 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 this. I'm not even so sure, my lord, whether that is unlawful, because the person that has been referred to, who the defense believes that later on will be called by the state, is amongst the list of state witnesses. So there's perfectly nothing wrong with that, my lord. Unless if the state from the beginning indicates that these are the specific names of witnesses that we are going to utilize in this trial, the rest we will not be utilizing. It is therefore upon those bases then we can approach the court and say, on the basis of the fact that the state is saying that they will not be utilizing this witness, may I then be granted leave to provisionally use the statement, because most probably this information is very important for the defense of the accused person. I may call these witnesses in our defense, and then the court provisionally then allows the usage or the content, the usage of the content of such a statement, my lord. But a blanket prescription that such documents cannot be used, my lord, I think it's unlawful and it has to be rational. What should actually happen is it should be a case-by-case determination. It should not be a blanket amnesty. I therefore do not align myself with the suggestion or with the application by my. I don't know whether it was an application, but I heard him saying that he was sounding a word of advice. I don't align myself with that advice, my lord. I may say from the bar that I'm not inclined to accept that advice. Thank you, my lord.
Okay. Yes, Mr. Ngumalo.
Mr. Court, this is my lord. Before Mr. Ngumalo addresses the court, I was called by my client to indicate that, my lord, the application or submissions by my learned colleague, my lord, are one-sided.
What?
Are one-sided because, my lord, he tells me that Brigadier Gininda has referred to the statement of Absolom Zungu, which he says links accused number 1 and 2. Yet that Absolom Zungu, the state did not call, and they led evidence to that effect. The evidence of Magaleni, who's the deceased, who describes suspect B, which the state alleges is accused number 2. Also, that person was never called to have not been furnished with the death certificate of that person. So, what he essentially says is that the state may be making this application, but what is good for the Genda, the warning that he sounds to us, he must also sound it to himself. As the court pleases me.
Yes, sir. Mr. Ngumalo.
My lord, the use of hearsay evidence is governed by Section 3 of the Law Amendment Act 45 of 1988.
Is that true?
Sorry?
Is it true or correct just to make that statement that hearsay evidence is governed by the Evidence Act, Section 3 of Act 45 of 1988?
There are various, I think there's about 7 requirements that must be met before one can.
Yeah, that's why I'm asking you, is it correct to say hearsay evidence in this case? Because according to what I understood from Mr. Baloi, those witnesses are alive. In terms of the Criminal Procedure Act, they must either be dead or missing.
Yes.
So that the court can find that in that instance, that evidence could be admissible in the interest of justice. But that's why I asked Mr. Ramosele yesterday, this gentleman who compiled the photographs, where is he? He's still alive. And he never answered me. Just said, oh, well, you know, I don't know. So I couldn't make a ruling then. Okay, go on.
No, I was also going to address the court on the basis that if the court is forewarned that the credibility of that evidence upon whose property value relies is going to be called, then that evidence may be provisionally admitted pending the calling of that witness. And in the event that witness is not called later, then that piece of evidence may be removed from the record.
Fine.
That's how I understood it.
Yeah.
So if the court in any proceeding, for instance in this case, is warned that the counsel is going to use an affidavit and this person is going to be called, then the witness may be cross-examined on the basis of the content of that affidavit. If the court is forewarned, then failure of the counsel in calling that witness that was referred to earlier, then that evidence is scrapped from the record.
Fine.
That's how I understand the whole procedure. Thank you.
Yes, Mr. Sherman.
My Lord, yesterday when we adjourned, the court granted us the indulgence to discuss with the state regarding the status of the content of the docket 375. My Lord, we did discuss the status of that docket, and the state indicated to us that since it was discovered by the state to us and we're in possession of that information, it can be used by the defense. Secondly, my Lord, it is the duty of each and every counsel who is intending to lead evidence on a particular statement, if the author or the deponent of that statement is no longer alive, to inform the court and bring the necessary application in order to be able to use such statement when cross-examining, especially this witness who is the investigating officer in this court. As a result, my lord, my submission is that since we have been given that permission to proceed, as the time when comes when the counsel intends to lead evidence on a certain particular statement, each counsel knows the procedure, my lord. That's my submission.
Yeah, but I thought he was speaking about photographs, documentary evidence. Is that not
Yes,
so?
yes, my lord. My lord, the photographs, unfortunately, my learned friend has decided not to proceed with that. However, the state had indicated that if he wants to lead the evidence regarding that statement, he can still proceed, my lord. And we also ask the state to make those witnesses available to us if the state is not intending to call them. And the state indicated that as soon as we indicate, the witnesses will be made available.
Okay.
Yes. Therefore, whenever counsel is or intends to lead that photo album, especially in my case, I will be calling that witness who took that photo album, and I will be using that photo album.
Is he alive?
He is alive, my lord.
Where is he?
Mr. Gininda can No, my lord, the investigating officer will be approached when we are about to lead that information to get the whereabouts of the witness for us. Because once the state has finished with its state case, he will make those witnesses available to the defense, and the investigating officer will get them for the defense. And then we'll be able to call them, all of them, my lord. We are going to give them a list of all the witnesses that the defense intends to call. That's the
Okay,
court.
fine, no problem. Yeah, that's a general proposition. This court is obliged. I've listened to the defense and even the prosecution. The government of this debate is the fact that Mr. Ramosele wanted to utilize photographs which apparently are the result of an investigation by the state in another case. And I think Mr. Baloyi initially objected that, but after some time relented to say if Mr. Ramosele wants to use that evidence, which is documentary evidence, he may deal with it as he wants. Am I quoting him correctly?
That's correct.
Right. Now, as we all know, the Constitution is the premier law in our country. What Mr. Baloyi stated about hearsay evidence is correct, no problem. And also what Mr. Mnisi states about Section 3 of Act 45 of 1988, the Evidence Act which came into being 1961. I'm sure all of us were born. It's correct. But there is a rider here. I asked, how was this evidence acquired by Mr. Ramosele? And Ramosele said it was apparently discovered by the state before this matter was nullified. Is that not so?
No, it was during this matter, the current matter, not before Justice Meyiwa. It was in this trial.
Oh, I see.
Yes.
Is that so, Mr.?
Well, and I don't want to cast aspersions on anyone. The main disclosure regarding 375 was done during the trial before Judge Meyiwa.
Yes, I think I listened.
Disclosing anything
That's it.
pertaining to as same or not we
No, fine.
memory can sometimes leave us in the lurch.
Yes,
but
I listened to say this was discovered during.
Yes, but
I even said my predecessors.
yes, that is my recollection.
Yeah, quite. But it was not formally discovered at the beginning of this trial on the 17th of July, 2023.
No, 375.
Yeah, 375. I'm talking about 375.
Yes, was discovered.
Was discovered.
During the proceedings that were aborted before Judge Meyiwa.
Yes, that's how I understood it. You don't agree, Mr.
No, I don't agree with that.
We were all in court. I wasn't here.
My lord, how can that be?
I was sweeping the floors when you were sitting with my brother Maumela. I wasn't there.
But my lord,
And you can agree
yes.
on this. You were there during Maumela's time, you were there, or you are here during my time.
But what the essence of my submission was that the question emanated from your lordship, not just this moment.
Okay, otherwise we'll waste the whole time. Yeah, okay, let me just settle it. In terms of our law, the Constitution, about Section 35, 1C of the criminal of the Constitution states that an accused person has the right to defend himself and to challenge the state's case also. Consequently, accused before court here, they have the right to challenge any piece of evidence. Like for instance, because it has been discovered, that this court doesn't have to inquire as to how it was discovered, because it appears that in any event, Mr. Ramosele wanted to utilize this evidence of photographs or an album. And I don't know in this case, wherever it goes, they say this judge never dealt with this exigency. So I'm dealing with it now. When you decide not to use it, it mustn't be said that I refused you the opportunity to use it. Okay? Because my finding, as I say, is that your client has the right to defend himself. And then in section 151(2)(a, at common law also, there has always been a right vested in an accused to call witnesses on his or her behalf. And that the Constitution recognizes this right in section 35, and also the Constitution now guarantees every accused person, as part of the right to a fair trial, to the right to adduce and challenge evidence. And this principle was reiterated in the case of S versus Duma. It's an unreported KZP case number AR 141/14, where it was reported that it is an irregularity if a judge or a court denies an appellant or an accused person an opportunity to call a witness in defense of so fundamental a right that, if that happens, it vitiates the proceedings in the sense that he has been deprived of a fair trial right. And this applies to all the evidence, documentary or even evidence relating to videos, photographs, and verbal recordings. All evidence. And this was also repeated in the case of Ugwebu versus the National Director of Public Prosecutions, case number 861/84/201, which judgment was delivered by my late brother, Classens, on the 28th of May, 2019. And at page 22, he says the court recognizes the right, and that this right is underpinned by a right to a fair trial, and entails that all available evidence, including evidence that would assist an accused in his or her defense, should be made available. All, irrespective of how that evidence was acquired or discovered. In S versus Maluleke, unreported case number CA and R 34/2013, which was finalized on the 1st of November 2013. The court at paragraph 60 confirmed that where the defense fails to call a witness whom he or she could have been called, it is open to the defense to request the state to make that witness available. And actually, to put it in its proper context, the state is obliged, if it doesn't utilize any witness or any document which pertains to a case in which the right to adduce evidence or the right to defend the state's case, that is by the litigant, the state is obliged to make that evidence available, whether it be, as I say, documentary, photographic, or through video material. So it's a legal question also that if the state is not in a position to call any witness, it is incumbent on the defense to do so if it so desires, in order to actualize the right to a fair trial and to adduce and defend evidence in terms of section 35(1)(c). This case is peculiar in the sense that this court finds that this evidence, which is apparently wanted to be used by Mr. Ramosele, which pertains to documentary evidence of photographs which were allegedly acquired or taken in another case, it doesn't stop Mr. Ramosele or any accused person to utilize that evidence, because the right to section 35(1)(c), in my view, is more decisive than the right to the privilege which is supposed to be extended to any evidential material which is in the possession of the state. Because we must bear in mind that this evidence, we keep saying it's a case. It's not yet a case. 735, it's not a case. It's still an investigation. The case only commences when there's litis contestatio, meaning that it only commences after the state has placed or put a charge to an accused person and that accused person pleads. Only then does that evidence become evidence in the accepted way. Otherwise, still an investigation. So Mr. Ramosele actually wants to use photographs which are pertaining to an investigation in another case. But I'm saying the right of his client to section 35(1)(c) supersedes even the privilege which the state could claim or wants to claim. Okay. So if you want to use that evidence, you may do so. Okay, thanks. Yes, Mr. Ramosele, any further questions?
As the court pleases, my lord. That's it. Now, Brigadier, yesterday I had started on an aspect of the description given by various people that were in the house, in particular regarding accused number 2. And that description is contained in the statements that they made on the 27th of October 2014. And for some of them, they are viva voce testimony also in this court regarding that description.
Yes, my lord.
Now, yesterday I had started on the evidence of Nthabise Mokete, and I had paraphrased some of her evidence and invited you to comment, but I'd like to start today with a proper premise by not paraphrasing, but by reading from the transcript of her evidence and invite you to comment. And the evidence is contained in the transcript of the 26th of July 2023, and I'll start at page 25, which Advocate Baloyi says, yes, you may proceed, and Ms. Mokete. Now, there was a stage where there was a sound, a loud noise that sounded like a gunshot sound. a bang sound like that of a firearm whilst we were still in the car like that. Now I got shot. I then said to her that it is the sound of a firearm or a firearm that is being discharged, and Mrs. Mokiti here, she's referring to Yolanda Nota that she was with in the car at the time. Should I proceed? Or you don't have Yolanda? Okay. Mr. Jones, they are printing it for you. And then Advocate Baloyi says, if you say you said to her, who are you referring to? Mrs. Mokete, I'm referring to Yolanda Nota. Advocate Baloyi, yes. And then Mrs. Mokete, now there was a person that passed or walked past at the time that I was saying to her that it is a sound of a gunshot. This particular person, as he or she was passing, that he or she went past running. In fact, he was running as he was passing where we were. Then Advocate Baloyi, you say he or she. Did you see whether it was a male person or a female person? Miss Mokete, he looked like a male being. He had a pair of pants, lean built in terms of the physique. Advocate Baloyi, now from which direction to which direction was this person running past? Miss Mokete, now when I saw this person, the person had already passed the vehicle and he was running towards the park.
Must I comment?
Yes, because the comment that I want to invite, yesterday you gave, when I gave this, like I said, it was not quoting verbatim. You then responded by saying, yes, this lends credibility to one of the confessional statements of accused number 2, because he had said that he ran away after the first shot was fired. And by then we were referring to a person with dreadlocks. So my question was that, are you saying that the person that ran out at the time with dreadlocks was accused number 2?
Yes, but my comment insofar as yesterday is concerned, my lord, was in reference to the statement made by her, not her testimony before court, because I wasn't here.
And the second question will be, the person that is described by Ms. Mokete after the firing of the first shot, he says it's a lean or slim person in physique. And importantly, she did not know where this person was running from, because as she looked, the person had already passed the car that she was in. Do you want to comment on that?
My lord, again, I was not before court. I can only comment insofar as what is contained in the statement. So it's a difficult situation to.
But you wouldn't have any reason to dispute her testimony that she did not see where the first person ran away from after the first shot was fired.
I will not dispute her testimony if that was put before court, because I was not here, my lord. That's the essence of what I'm saying.
And at page 26 of the same transcript of the 26th of July 2023, it will be at line around line 17. Ms. Mokete says, as we were busy arguing with each other like that, there was another sound of a firearm that is being discharged. And Advocate Baloyi says, now this second sound of a firearm that is being discharged, it sounded as though it was now close to the vehicle. The sound was closer to the vehicle. And it says, Advocate Baloyi, I presume that the person that was talking, that the sound is closer to the vehicle is Ms. Mokete, but they wrote Mr. Baloyi. And below Mr. Baloyi says, yes, you may proceed, Ms. Mokete. Now, after that sound, the people that passed running towards the park in the same direction that the first person who passed running to. And Advocate Baloyi, I won't read that. We go to line 15. Mrs. Mokete says, now, as she opened the door, mind you, the people that we have already seen had run down the street. Then there was a third gun sound. Now, as she opened the door, I also tried to open the door because now the gunshot went for the third time.
We are both looking, Madam.
Page 27, line 2.
We are on 26.
6, 8, line 18.
Yes, my lord, I see that, but if one looks at page 27 on top, that's the comment I can make. It starts by saying running towards the park, the same direction that the first person who passed running took.
So sorry, Brigadier, before you proceed, it will start from the last sentence on page 26 where Ms. Mokete says, now after that sound, 2 people passed running towards the park in the same direction that the first person who had passed running.
Indeed.
Just before Brigadier Gininda comments, we've allowed this cross-examination to continue, but the court will recall that at some point, I think it was Advocate Misi objected to Brigadier Gininda giving an opinion and said he's usurping the function of the court. Now, here's evidence that is before court. Now, Brigadier Gininda is now invited to comment as to who is the person that is being referred to here. It's our submission that once evidence is before court, it's now for the parties to argue on the probabilities as to who the person is that is being referred to here. It cannot be left to the witness to then give an opinion as to who is the person that is being referred to here. At the end of the case, based on all the evidence that would have been tendered, based on the probabilities, it will be for us to argue as to who, in all probability, is the person that is being described here. It cannot be left to the witness, my lord, to give an opinion on that.
Yes, Mr. Ramosele.
As the court places, my lord, let me skip this part and go directly to what I said. My purpose was, I was just giving the background of the sequence as testified by Ms. Mokete. But the main point that I wanted to come to is on page 26, she has already given a description of the first person that ran away past the car after the first shot, that he was lean in physique. Now the descriptor of the 2 other persons that ran thereafter, it's contained on page 34, and that's the sole reason why I embarked on this exercise, my lord. Not even so, I think I made you print the page, it's not page 34. Sorry, my lord, it's not on page 34, it's from page 45 to page 46 of the record of the 26/07/2023, my lord, and that reference will be at line 15 of page 45, and it is Advocate Baloy saying, you mentioned that the first person was a shot that rang off and a person ran past, and you described the person, you mentioned that the second shot that rang off and 2 persons ran past towards the park. Are you able to describe those 2 persons? And Ms. Mokete says, no, I remember the very first person that ran past was tall, he was not short, also with a leaner physique or a slimmer physique. And then Mr. Bolis asked, is that the first person who ran past alone? And Ms. Mokete, the very first one who ran past alone. Yes, and the other 2, Ms. Mokete, one of them was not, big in terms of the physique. He was neither lean as well. He was of average height, and I remember that he had dreadlocks. And at line 17, Ms. Mokete stated that now this other one, who was slightly bigger in physique, they did not outrun each other. They almost ran side by side, even though there was, and with a demonstration of fingers and in brackets written, that there was one that was a little in front of the other, and the very one with the bigger physique had a hoodie on his head, and with that with that hat as well, he was taller. He was taller than the other two that I have already referred to. And he was asked by Mr. Baloyi, yes, any other description that you can give, Ms. Mokete? There is no other description that I can give. So essentially, the person that she described as wearing a hoodie is one of a bigger physique, not one of a thinner physique, according to her testimony here. And then she goes on to say, and with that head as well, he was taller. He was taller than the other two that I have already referred to.
My lord, my comment can only, as I've said, I think yesterday, can be perhaps twofolded. One, that the three suspects that Ms. Nthabiseng saw is corroborated in the confession of accused accused 2. In that, he says he ran away after I think 1 and 2nd shot were fired in the house. He went out. He then refers to accused 4. He leaves accused 3 inside according to the confession, and then accused 4 goes inside. So when he ran out to the car, that is according to the confession, my lord, he was running alone, and this is corroborated by this Nthabiseng, my lord. Thereafter, the second 2 people that Nthabiseng is referring to, my lord, identifies one person with dreadlocks whom it is alleged, my lord, or the investigation pointed that the accused 3, in terms of the investigation, is the person with dreadlocks on that specific day. Now, what we do not have, my lord, in the investigation is what accused 4 was wearing. The fact that the second suspect is described in the second grouping now as having a hoodie does not necessarily mean it's not accused 4, because I don't have a description and we did not find evidence indicating what was accused 4 wearing on that specific day, including accused number 1 and accused number 5. We can place them where they were, but we can't say, I don't have evidence to indicate what type of clothing was accused number 4 wearing on that specific day. The only description of the alleged suspects, my lord, that is given by the witnesses is insofar as the person with the dreadlocks, where they describe the khaki or brownish jacket, Mr. Makeleni, I think we dealt with him, who identified or assisted rather in the identikit of the second suspect, where he described the black hoodie, which is corroborated by Mr. Zoom. So those are the recollection of the description in terms of the clothing that I recall. I don't recall having evidence that points to what exactly accused 4 was wearing, my lord.
I just have one comment. I'm having a problem with the line of answering by the Brigadier, because he's making reference to my client, and there's no question that was asked by my colleague with reference to my client.
He's giving evidence.
To which question?
We just asked, according to him, he's giving evidence.
I'm not happy.
It's a hypothetical situation. Listen to what I'm saying. A witness testifies about 4 different people, and he says accused number 1 did this and this and this and that, and it is your client. So he now, because he's your client, not testify about what number 1 did. He must now jump and say number 2 and 3 did this and this and this and this. Is that how you're raising it?
My lord, I'll leave it like that.
No. Let's debate it. Is that how you are saying evidence should be led?
It was with respect to the questioning by my colleague.
Yes.
Mr. Ramosele.
I don't
He stresses the point. He stresses the point with reference to my client. Instead of answering the question, the direct question that was asked to him.
So they say you are stressing the point about his client.
No, my lord. If I may say, my lord, and this is what I'm saying, the question was put to me, and I started by saying a collaboration, my lord, which is contained in the confession statement of accused 2.
Yes.
And I'm saying, what is it that he's saying? It's not me. It's in the confession where accused 2 says as he ran out, there was accused 4 who went in. I'm not stressing it is contained there, my lord. And I'm saying if you take that context and you take it to what Mr. Ramosele referred me to, insofar as Ms. Mukiti is saying, I'm saying there's a collaboration. And that is why I'm saying, because we do not know what accused 4 was wearing, one can think that possibly it was him who's wearing hoodie. That's why I was going with my answer. But I'm simply commenting or responding because the question has been put to me, and I have to comment about these 3 individuals whom Ms. Mukiti saw. And I'm talking about that collaboration.
Brigadier, if you listened to the objection by my colleague, Advocate Baloyi, And hence I ran away from the passages that I was reading at the beginning and went for the description. I sought your description, your comment on the description as per Ms. Mukete. Because Advocate Baloyi says, as to who Ms. Mukete saw as the first person running, that is an argument that he will make at the end of the case. It is not your duty to draw inferences about the mind of Ms. Mukete, that this person that was running there, therefore Exhibit H, and JJ, Mukete says it's that person. It's not her testimony. Hence, Mr. Newman is not happy because you didn't answer even my question. You went on a drift to show that you can draw inferences, which is not your duty.
No, but my lord, that's not correct. I didn't even utter one word of inference. I was asked a specific question to comment about 3 individuals that Ms. Mukete referred to.
Yes.
And my response was in relation to 3 individuals as per the confession of accused 2. So I don't understand where am I quoting it correctly, because the question from Mr. Ramosele, it's in relation to 3 descriptions. I mean, the description given by Ms. Mukete about 3 different people.
Yes.
And I'm drawing that inference from the confession of accused 2 that relates to 3 different people. How could that be? Because then I don't know how to answer it, my lord, because I was asked a specific question and I answered it in that context.
You even used the word, you drew an inference from the statement of accused number 2. I was only asking you because other witnesses have described the person wearing a hoodie as a lean or slim person, tall, slim. Ms. Mukete describes that person as the one with a bigger physique. That's the invitation I was calling for you to comment on.
No, my lord. Again, I disagree. I think I was even fair to say, insofar as accused 4 is concerned, that I do not have evidence of what he was wearing on that specific day. But my response, my lord, was insofar as the 3 individuals that I'm being asked about described by Mrs. Mukete, I'm corroborating that with what is contained in the confession statement, not what I'm thinking or what I'm drawing or trying to think the investigation led me to. I was very specific to say this is what I'm being referred to insofar as Mrs. Mukete is concerned, Ms. Mukete, and this is what is contained in the confession statement of Mr. Ramosele's client. It's specific. It's not an inference that I'm drawing. So my answer was based on those, my lord.
Brigadier, now just to tie up that point that we were engaging on before the break, are there any witness statements that say they saw suspects running away from the crime scene, that is the Kumalo household?
Yes, I think there is, my lord, but one will have to go through the first volume to be specific, so that we can go through them. We can share them. But I have a recollection of, I think the Marshes or saying something to that effect, my lord. And the late Mr. Mukete as well, the one that we spoke about, I think he does talk about someone running away as well.
Mr.
Makaleni, sorry, the deceased, the one who assisted with the drafting of the ID kit for the second suspect.
Those witnesses specifically say or said, I saw suspects running away from 13511 Kutlandong Street, Mzamo section, Fosloras, on the 26th of October 2014 from between 2000 hours and 21:15 in the evening.
No, there's not even a single witness that says that, including the people who were in the house, my lord. They don't explain it in that context.
Yes.
There's no one who puts it specifically like that.
So what are those witnesses that you say you can check? What are they saying?
My lord, I think so that one does not misquote them. If I can be given an opportunity, I think we can embark on that exercise.
Yes.
But my recollection is like you'll have inference like saying Makumalo's house or Kelly's house. That's how they describe the crime scene.
Yes, I want that.
Yes, yeah, but I don't think there's even a single one in my mind that I recall that identifies the house in terms of the house number and the time. Yeah.
Hence I said in a generic form the crime scene.
Yes, no, in a generic form, my lord, I think we may find those statements. I'll just have to give you an opportunity. So
I'll give you that opportunity so that during the long adjournment, then we can revert to it after the long adjournment.
Okay, man.
Now, you will recall as well that before these particular accused persons were arrested, Mr. Mbata was arrested for this matter, and an identity parade was conducted in that for that suspect. You call that?
I do recall, my lord.
And in this instance, specifically regarding accused number 2, after his arrest on the 16th of June 2020, why was an identity parade not conducted for him in respect of the people that were in the house?
My lord, I do recall specific in 2 instances, the 2 people that I interviewed, and that is Mr. Mthokozi Sitwala and Mr. Matala, who said they were 50-50. I think they put it in that context, that they are not 100% sure that they will be able to do an identification parade. And I think I took their statements because I know they put it in the middle, so it wasn't going to take us anywhere. Insofar as the others, as I've said, my lord, the investigation was procedural driven. You sit with the prosecution and you are guided as to which witnesses you can use or not. But those 2 specifically, I interviewed them, and they gave a statement to say they're not 100% sure. It's 50-50. I think that's how the statement is quoted.
Now, regarding the rest of the people that were in the house, what decision and why was it taken that an ID parade, they shouldn't come to an identity parade where accused number 2 will be part of the people that are in the lineup, so that they can have an independent identification should they identify him at that parade, rather than what transpired here in court, him being identified from the dog.
My lord, like I said, the first part, like I said, the 2 witnesses that I interviewed said they were not 100% certain, so they didn't rule out the possibility, but they also could not confirm that they will be able to identify the accused because of the period that it has taken. And as such, as I said, my lord, I took statements to that effect. The others, as I said, it was procedural driven investigation. There were guidelines and given as to who we can use and who we cannot use. That's how I can answer it, my lord.
Now, if I may assist you, one of these statements, it's A126, and you can find one for yourself. I think A126 is in respect of Tumelo Madala, whom you took a statement from inquiring whether or not he will still be able to identify the perpetrators, and he said that this case has been a while back, the incident happening, therefore he was equivocal. In other words, he wasn't sure that he will be able to identify the persons that had allegedly entered the house on the 26th of October 2014.
Yes, my lord, that's why I'm saying Tumelo Magana do recall, but he didn't say he will not be able to. It was just a middle-line to say, because of the time period, like you're phrasing it, is not certain. It was a 50-50 type of response that he gave, my lord.
Okay. Now, let's go back to the issue of the identity kit. We have seen Exhibit BB, which is the identity kit that was compiled on the 29th of October 2014. Did you subsequent to that request warrant officer still come to compile another identity kit with regarding accused number 2?
Yes.
Altering the image now that is Exhibit BB?
No. So the question is twofold, my lord. The first part, yes, I did contact warrant officer Stenkamp to assist with the photo that I had of accused 2 who was arrested. The second part, not to alter the initial identity kit. It was to say, this is the picture. If I recall, I think the picture was either coming from the identity document after accused 2 was arrested, my lord. And I asked her if she can take this picture and see if this picture, and if she puts a hoodie on accused 2, will it not be closely resemble the picture or the identity kit that was crafted on the 29th of October 2014? So that was that, but not to replace or alter. So we have 2 submissions. There's this identity kit of the 29th of October 2014, and when I asked her to assist with what I had in seeing that we can see similarities or not from her expertise, my lord. That's how I asked her. The essence of that request, my lord, was to try and ascertain from her whether she can link this photo that we've given to her when the hoodie is inserted with the photo that was crafted or drawn on the 29th of October 2014, my lord.
Now, your index number will be A154.
A154.
Yes. My lord, A154 is another report by Warrant Officer Steenkamp, Amanda Steenkamp, who is the facial image analyst, who also compiled the initial identity kit Exhibit J, from which Exhibit BB was extracted. And with leave of the court, once the Brigadier has obtained the relevant document from his docket, I beg leave to take it through.
Yes, my lord, I do have 154, A154.
Okay. Now, this report was commissioned on the 19th of June 2020 in East London. If you can assist me, Colonel, by going to the commissioning part, who the commissioner was, and the deponent is Amanda Yvonne Steenkamp.
Yes, I don't know this person, but it's someone from East London. It's A-Labes Strachen, look like that, my lord.
Streicher.
It's Petros Paulos Engelbrecht. Robelar, yes.
Okay.
Robelar, he's a lieutenant colonel.
I'm going to go through this, Brigadier, and there may have to be a time when we revisit it again, because I forgot in the morning to give it to my learned colleague so that he can scan it, so that the accused person, accused two in particular, could also view this identity kit as you are commenting on it. But I've already consulted with him regarding that he's aware of this new identity kit, and by new I'm saying subsequent to the one of the 29th of October 2014.
Correct, understood, my lord.
And at page, there's no page number, but the second page will be, and I read, Foslo Raskas 63610 of 2014, hereby I, Amanda Yvonne Steenkamp, under oath in English, paragraph 1, occupation and position in the South African Police. I am a warrant officer in the South African Police Force number, stationed at the Facial Identification Unit at the local Criminal Record Center in East London, where I am employed as a facial identification specialist with telephone number. Qualifications and experience: I have 28 years service in the South African Police. I am employed as a facial identification specialist at the South African Police Facial Identification Section since 1997. The functions I perform on a daily basis include the following: facial compilations, facial comparisons, facial mappings, two-dimensional facial reconstructions of decomposed bodies, and facial aging. I received training the facial identification functions at the CRC Training Center in Pretoria and facial identification expert status during 1998. I also gave presentation regarding facial comparisons and facial comparison at the Facial Comparison Symposium hosted at the School of Anatomical Science, University of the Witwatersrand on the 1st of March 2015. During 7 August to 13 September 2006, I gave evidence in the South Gauteng in the following cases: the case of State versus Nkosa and 4 others, a medal theft case.
Sorry, why are you reciting all that?
Yes, so my lord, let me go to the relevant part, which is, I'll skip paragraph 3, that it should be mutatis mutandis with this paragraph, same paragraph in Exhibit J. The relevant paragraph is in paragraph 4. On 16 June 2020, I received a request from Colonel Gininda to do an alteration on an image by adding a hoodie and dreadlocks hairstyle to a person of interest. I performed the alteration using Adobe Photoshop C52 or CS2 by adding dreadlocks hairstyle and hoodie with a brush tool. Attached, please find Annexure A, the draft document in brackets that forms part of this affidavit, containing identity kits and control images. Paragraph 5 is the commissioning that we have just referred to. And then page 1, Annexure A, it reads, Phosphorus CAS 636-10-2014, a facial composite is a method of establishing a visual likeness of any person through the verbal description of a witness or victim, and which is built up with the aid of identity equipment by a facial technician. The facial description must be established as well as the modus operandi of the sought person to aid the facial investigation. And it says, Annexure A is a draft document for investigation purposes. Page 2 is the suspect information of a person of interest, and page 3 is the identity key, control, and altered image. And page 2 thereof, it's Phosphorus CAS 636-10-24. Mr. Makaleni, residing at Mzamo 3942, compiled the face of suspect B. He saw 3 unknown African males in the vicinity of the gas station busy on their cell phones. Later they saw them outside the house of Kumanos. He saw the suspect B at the gate and gave the following description: plus minus 25 years old, plus minus 1.80 meter tall, slender build, a golden insert in upper teeth, not sure, in brackets, regarding the golden insert in upper teeth, dreadlocks hairstyle, facial hair, mustache and beard. He saw something in his hand that, not sure if it was a firearm, witness could not compile the other faces. And there's an explanatory with second suspect, identity kit, unknown African male, plus minus 25 years old, slender build, height, plus minus 1.80 meter tall, medium brown complexion, upper teeth, saw a golden in the upper teeth, not sure which side, prominent cheekbones, dreadlock hairstyle, facial hair. And then, as you correctly say, Brigadier, the control image that was used, there are 3 images. The first on the left is the image that is of the image on the left in Exhibit J, and the one in the middle is the actual photo of an extract from accused number 2's ID. And then I think the last image is the one where it was now superimposed or altered using a hoodie.
Correct, my lord.
And there's also this other one. You have it in front of you.
I think let me just confirm, my lord. I have something like that, but it's just that the wording is written differently. But I do have something to this effect, similar to what you have, but I think it's the writing that is slightly different. Yeah, because this one is an enlarged of this page, and it says this suspect was standing outside the gate, and the descriptors are the same as in the pages that I've read. Yes, I'm not sure if. I just don't see the way that you've seen, but the picture, yes, there is a picture resembling what I was shown, my lord.
Yes, like I'm saying, this exercise is going to be futile if it's not being there, so that there's no repetition when I ask you to comment on it. I was just placing it on record so that when it's placed there, I've already placed it on record. So I'm going to request that also this one could be done after lunch. I'll ask my learned colleague to scan it for us so that it can be built.
Understood.
Now, the questions that I can ask from this, whether or not we're going to do this, is what was the necessity of having this second identification altered from DB to this other one now with a control image of his identification document used?
So my lord, there was no intention to alter, it was to compare. So that is the right context. The alteration, insofar as what was provided warrant officer still come, and the altering she's talking about is what we provided to her to put the hoodie and the dreadlocks as is described by Mr. Makaleni in order for her expertise. As I said, my lord, the purpose was to see if she can say photo B or the sample that we gave her corresponds with the identity that was taken on the 29th of October 2014. That was the purpose, to say you are an expert, you dealt with this identity on the 29th of October 2014. Here's the picture which does not have a dreadlocks of a person of interest. Can you then alter this picture that we're sending and add the hoodie and the dreadlocks and see if you can match the two? That was the purpose of this exercise, but not to alter the original identity of 2014, because the comparison was being done in relation to that original identity, my lord. So the purpose, in essence, my lord, was to try and see if we can link conclusively accused to as per the photo that comes from this ID with the identity kit that was drawn on the 29th of October 2014. That was the purpose. Or exclude him if, for example, the expert says no, there's no such in terms of her expertise, my lord.
Noma ke uma ungoti ethi ke cha ulokhu ke sengikwenzile ke lokho kodwa ke ngiyathola noma ngiyabona ke ukuthi cha akuhlangani bese ke eyakhishwa ke awukuthi nje ahlanganiswe kodwa uma kuwukuthi akukho okutholakalayo akhishwe.
Where was accused number 2's identification document taken for it to be supplied to Ms. Gininda?
It was taken by the arresting officers. As I said, when they arrested him on the said date, my lord, they did let me know. So it was electronically communicated, as Warrant Officer Steenkamp was sitting in the western, not the western, the eastern Cape, East London, sorry, in East London, my lord.
And other than Makaleni, and whom we've established now, that he's not the person that was in the house, is there any other person that made a statement to the effect that the second intruder wearing a hoodie also had dreadlocks, because the description of dreadlocks from the people in the house only related to the first intruder?
That is correct. All the people in the house relates to the first intruder with the dreadlocks. That's okay. That's what it says. I agree with you.
Yes, but my question is this. Other than Makaleni, that we know that he was not in the house, are there any other witnesses that describe the person that they saw running wearing a hoodie, having a dreadlocks hairstyle?
My lord, I may speak under correction, but I seem to recall that the statement we dealt with before tea time of Ntabiseng or the record maybe saying something to that effect, but I'm not sure, my lord. All I can say with certainty is that the people who were in the house only describe the first intruder with dreadlocks, and they don't say the second one had dreadlocks and a hoodie. That's what I can say with certainty. Insofar as to whether there are other witnesses outside, one will have to be have an opportunity to go through all the witness statements and then give a certain answer, so that I don't seem to be saying something that contradicts the docket, my lord.
Now, Ms. Zandile Khumalo and Lieutenant Colonel Mangena testified about a reenactment that occurred around 2016 regarding the events that transpired on the 26th of October of 2014. Are you aware of that reconstruction that was conducted? That was before you even were seized with this matter.
The only construction, and I don't know if I assume, I'm assuming, my lord, and I stand under correction. The only thing that I seems to recall, it's where General Mokotedi and I think with Brigadier Modise were involved, where they used actors to try and reconstruct the scene. I'm not sure if
that's the one I'm referring to.
Yeah, I have a recollection of that, my lord.
And the gist of Ms. Khumalo's testimony in Zandile is that they were called to 13511 Kukutlano Street, Muzamo section for Sloras on that day, and using props, like we say, sort of an acting out and reenactment of that scene. Each person that was in the house in 2014 was called in to say, we've set up the scene, say this thing is Senzo, this one is the intruder, and explain how it transpired. But the gist of why I'm asking you this is, initially, I think at the beginning of the year, or even last year already, I had asked the state to provide us with a copy of the DVD of that reenactment, because I have a statement of a warrant officer Boysen who says he also attended that reenactment. he took videography of that reenactment, copied it into an SD card, and later made into DVD. And I haven't had the benefit of the positive response, whether or not that DVD is still available.
My lord, I'll assist. I suppose then the defense wants to have access to that DVD, so I'll assist. I'll try to go through the electronic data that we receive with the docket when I sign for it and identify it and make it available to the defense. So I'll just have to go through the electronic data, my lord, that was given to us.
That will be greatly appreciated, Brigadier.
No, I'll do my best, my lord.
Now, yesterday, because we were going up and down, I left, and when we were talking about the incident of the 18th of, we had spoken about the incident of the 17th of June 2020 at the boardroom in Pretoria North, where accused number 2 instructs me that you were present and you say you were not present. That will be something that will be argued, and what transpired in the boardroom. Then on the 18th, we go to Carltonville at Sibanye Gold, where accused number 2 was employed, and you said primarily to check on his alibi that he was at work at the time the incident took place. Is that correct?
That is correct, my lord, absolutely. But also just to go back on the date of the 17th, my lord, I seem to recall that it was said, I asked accused 2 to take off his clothing. I'm not so sure whether the
Yes.
top part to check for tattoos.
Yes.
My lord, there will be no reason to do that because there is no statement in the docket, and that's why I said I was not there. But even if I parked it, in the docket itself, there is no statement by either the people who were in the house or outside who gave a description of tattoos. So that exercise, even if I was present, I wouldn't ask me to do that because there's no description that is given that the second suspect or even the first suspect had tattoos. You can just, the description in terms of the dreadlocks, the clothing goes insofar as that, but no description of tattoos was given, my lord.
My lord, I beg leave to approach accused number 2. He sent this list.
Yeah.
Thank you, my lord. I mean, that's it. Now, accused number 2, you stated that you then confronted accused number 2 with a copy of the identity kit exhibit BB, and you informed him that the person on the left with the hoodie bore a resemblance to him, right?
Yes, according to my observation. So I was basing that on my observation, my lord.
And further that, you then confronted him and said, I'm sitting with information that shows me that you are a person of interest or a suspect in the Senzo Meyiwa murder case, right?
Yes, I did, but that's not how the sequence is correct. But I think the sequencing is not accurate, my lord. That was put at the beginning, after he was warned according to his rights, and that this assertion that he was, I'm sitting with information that he may be involved in the murder of Senzo Meyiwa, that was put at the beginning. Subsequent to that, then a response was given to me, my lord, that no, he was not there. And I even alluded to the fact that, my lord, it was interesting to me, or I find it interesting in that he was able to specify the specific date of this incident, the 26th of October 2014, that he was at work. And then subsequently, then we followed that alibi, which was found to be false. So that is the sequence that I'm laying. Thereafter, after the alibi was then denied, then the identity kit then kicks in terms of saying my view relating to the identity kit, which was also denied by accused number 2 in terms of him saying it's a mistaken identity. That's how it unfolded, my lord, leading to the identity kit confrontation.
And at Carltonville, where accused 2 was employed, you then attended upon 2 areas. One at Human Resources to find the cloaking records and other related documents regarding the status of whether or not accused number 2 was working first and whether he was at work on the 26th of October 2014, correct?
I don't recall, my lord, that it was two places. It was one facility, and Mr. Mulder was having access to the history in terms of the activities regarding accused 2 on the specific date we're inquiring about, and the activities of the clocking record. One will see that, my lord, that on the 22nd, when we finalize his affidavit contains the clocking record of his movement around this period, my lord. So it was Mr. Mulder who actually was able to gain us access to those activities.
Yes. When I say you went to 2 separate departments at Sibanye Gold, didn't you also attend to the hospital section also to obtain medical records for whatever purposes your investigation directed you to?
No, I don't recall that, my lord. The examination where I was present when accused 2 was examined was on the 22nd, after he made appearances on the charge of possession in Northwest, and subsequently then I think we went to Dr. Tokwe. That's my recollection, and that is where the dental report was given.
Okay, now let's revert back to Carltonville. Accused number 2, it strikes me that at Carltonville, indeed, he led the investigative team to his shaft where he worked, and clocking records and other HR-related documents were obtained. And thereafter, he was taken to the hospital section because there was an issue to check whether the accused had an injury during a mining accident that the investigative team wanted to follow. And if also I'm correct, Sergeant Mohale testified to that effect that accused 2 was taken to the hospital section of the mining complex for that purpose.
My lord, if he was taken, and if Sergeant Mohale testified to that effect, it would have been before I arrived. When I arrived, as I said, my lord, the sequence of events were exactly as to where he was. Alibi followed, found to be false. Identikit, which was then denied by him. I warned him according to his rights. Then as I was leaving, I was then called back by one of the members, and that led now to the confession, my lord. And after we'd agreed that he is prepared to make a statement to an independent police officer, I departed with Sergeant Mohula. So there was no other activities where I went to attend to with accused number 2. The only encounter that I had with him, insofar as the medical section is concerned, it's with the doctor, this Dr. Tokwe, on the 22nd. That was the following Monday of June 2020, my lord.
Okay. Now, with respect to now that aspect of you arranging that a statement be obtained from accused number 2 because he had made certain utterances. Accused number 2 will testify, and he has already said in the trial, within the trial, that at Sibanye Gold, you did not confront him with Exhibit BB, the identity kit, but rather you confronted him with a photo that is part of Exhibit S, that will be photo 47, which depicts a red motor vehicle with persons around, and in the background on the other side of the car there is a person wearing blue clothing with a cap.
No, that's absolutely not correct, my lord. My lord, and I think I dealt with this part yesterday when I was dealing with the issue of the see-through bag. The downloads, insofar, because what is referring to is contained in the downloads of accused number 3 cell phone. That picture with the red car, it's a sedan, and there are people appearing there. That picture, my lord, was found in the downloads of accused number 3. Now, I indicated that on the 16th, we were not in sight of accused 3, 4, and 5. It is after the confession of the 19th, obviously him talking to me on the 18th and subsequently it being written down on the 19th and 24th, that the analysis towards accused 3 in terms of the case number, the firearm that was seized from him, exhibits taken from him, were actually paid attention to. Now the statement from the downloader, this is now Sergeant Mabasa, from Brixton, where the downloads of Accused 3 were contained, was only made available or commissioned on the 17th of August 2020. So I could not have shown him, the essence of what I'm saying a lot, I could not have shown him a photo that is contained in the downloads of Accused 3 cell phone because I was not in possession of those downloads. The first data came to me around August 2017 when I received it from Sergeant Mabaso. Then subsequently, the analysis was done by Kenneth Stain. So that is not correct. I was not in possession of that picture. And my lord, I even said that is why I had no knowledge of this see-through back when we went to interview Accused 3 on the 30th of June, because Accused 3 was interviewed and measured on the 30th of June 2020, because I did not have that see-through back picture and the linkages even when we went to interview him. So on the 17th or 18th rather, when I came across Accused 2, I had no access to the downloads in that picture.
Let me just correct myself, Brigadier, because Accused 2 has just mouthed to me to say, in fact, it was not at Carltonville when you confronted him with this photograph. It was at Pretoria North, SAPS, on the 17th of June 2020 in the boardroom. And he says specifically that it is you who showed him this picture with the person in the background with a cap with insignia that I cannot see, that is slightly bent, to say this person is accused number 2.
No, but my lord, that's misleading. That's not correct. The same explanation I gave applies to the 17th of June. As I said, the only time the name of Accused 3 came into our picture was on the 18th, not even on the 17th, because I didn't see the accused on the 16th, Accused 2. I didn't see him on the 16th, I didn't see him on the 17th. The only time I came across Accused 2 for the first time was the 18th. So there is no way I would have shown him this picture on the 17th, because it was not even in possession of this team. We're not even aware, because Accused 3 was not on site as part of the persons of interest. So it's not true, my lord.
Now, on this particular picture, photo 47 of Exhibit S, during Constable Zungu's evidence, he was also led by my learned colleague, Advocate Baloi, regarding this picture. And his testimony was on the 7th of September 2023, and it will be at page 10. And it will be the specific section that I want to go to is line 19 of page 10 going on to page 11 up to the top of page 12.
Yes, my lord. Just to add on, to qualify what I was referring to with regard to the events of August. Now, in the statement which was discovered to the defense, A194 is the statement of Sergeant Mabasa, the downloader. Yes. Paragraph 5, my lord. In fact, even on this date, he was still doing the downloads. Paragraph 5 of A194 reads as follows, my lord. On 2020-08-17, at about 11:17, I received a CD from the phone downloads office with a computer folder marked Cleveland Case 962-2015. This is the case, my lord, when we're doing the analysis on Accused 3, we picked him up on. I testify about this. Containing a phone download information. The computer folder contained 3 X-ray files that contain the information of 1 phone, 1 SIM card, and 1 memory card. The information in the XRY format cannot be tampered, edited, or manipulated. Paragraph 6. The information contained in XRY file was as follows: Samsung GT E2220, cell phone number 072-766-8169. This number, my lord, is the one that I said we're able to link it to Accused 3 to show that this was his downloads. Then there's email number 359-796050297902. IMSI 65501224915137 and a memory card that belongs to Mtobisi Gada Mube, suspect linked to Phosphorus 636-10-2014 as directed by Colonel Gininda. That is the essence of what I'm saying, my lord, that these activities regarding this only took place later in August. So there is no way, and this picture This picture that was displayed, my lord, is contained here. So in June, I did not have access to this information. It was only made to me available later. So I could not have shown you this picture, my lord. And this statement, my lord, just to end the last part, was then was made by Sergeant Mabaso and commissioned on 2020 August the 17th at 14:23, my lord.
Same day.
Yes, 17th August.
When he says he actually downloaded it.
Yes, same day, my lord. But it's August 2017. Same day, my lord. Yes.
And now let us go to that particular identity kit where the control image used was the ID. I've requested my learned colleague to download it for us so that it can be beamed. So I request that it be beamed, and then I can take you through that.
Okay.
Just go to the photos. Let's go to it. Yeah, thank you. Now, this is the ultimate Photoshop Adobe that was used by Warrant Officer Steenkamp. And as I was reading and taking you through before it was beamed, on the left, will you agree with me that it's the same picture that forms part of Exhibit BB depicting the sketch of the person on the left in Exhibit BB?
Yes, I'll agree with you, my lord.
And in the middle, it's the extract from the actual ID document of accused number 2.
Correct, my lord.
And then finally on the right will be, I believe, Warrant Officer Steenkamp will come and testify about that. That is now the Photoshop of the middle picture superimposing the ID with the hoodie and the dreadlocks hairstyle, although the dreadlocks are not quite visibly clear on the picture on the right.
Yes, that's the report she gave me. I agree, my lord.
Now, as a lead investigator who relied on Makalene's statement, who introduced the second intruder or suspect B wearing dreadlocks, having the golden insert on his tooth. Remember, I asked you a question when you were looking at Exhibit BB, and in particular the picture on the left here and the sketch on the left in Exhibit BB. You were given pointers to see what can you see and describe protruding on the left and right hand side of that picture. Remember that question?
I do remember, my lord.
Now, with the benefit of your request to Mrs. Steenkamp and the statement that you relied on of Makaleni regarding the photo on the left, although it's not that clear as in BB, can you then describe what you observe on the left and right hand side of the features in the first photograph? Maybe you can go to BB because it's much clearer than this.
What I observe?
Yes, this here.
On the side?
On the sides, yes.
I can't see clearly, my lord. I mean,
Yes,
I can look.
as I said,
Yeah,
perhaps if you go to BB and Mr. Wasiwanda, please assist me with what you can see.
Yeah, I can't see clearly.
Yeah.
But what is prudent to mention here, my lord, this exercise was not for me to make finding. It
Yeah,
was
sure.
to get the expertise of the expert to say what is her finding. That was the essence of this exercise.
Yes, here, your observation, the photo on the left, and to my question, what do you observe?
I do, well, I see the similarities with the previous photo, my lord, and I suppose what appears to be the darkish stripes on the left-hand side, just below, just next to the cheeks, left and right-hand side. I don't know, maybe
Yes.
that's
Yeah.
where the question is going, yes.
And you said, what did you also say? I missed that, Brigadier. I missed that.
Which part?
The one that you have just described now, what you see on the left and right hand side. Of
I'm saying the similarities of this picture on the left hand side. I mean, this picture on the left hand side is similar to the one that we just saw, where there's 3 pictures of the same person. But here it's clearer that on both left and right hand side, there's sort of like blackish marks, if I can call it, which it was put to me, my lord, that is like dreadlocks protruding on the left and right hand side. So that's what I can see.
And with people in the house having not described the second intruder or suspect B to Mrs. Steenkamp, what was the purpose now of you requesting her to do that alteration with the superimposed identity document?
Yeah, so my lord, I think we dealt with this part, and we can go through the statement of each and every person that was in the house. I did indicate that as much as Mrs. Steenkamp said they did not, Warrant Officer Steenkamp to be precise, did not mention the contribution which was attributed by the people who were in the house. If you look at their statements, the statements of the people who were in the house, they do give a description of the second suspect in terms of being skinny, tall. That is there. I went through that exercise now during lunchtime because you said we must check as to even if anyone from the neighbors described seeing people running out of the house.
We'll come to that. Finish this one.
Yes, yeah, I'm finishing there. I'm not going there. I just want to give you the context that in that process, then I had the opportunity to go through the statements as I was doing that exercise of the people who were in the house. They do give a description of the second suspect, my lord, in terms of being skinny and tall, and we can go through each and every one of those people who are in the house. There is the description. It's just that Warrant Officer Steenkamp, in her summary, she puts Makaleni insofar as the identification of the second suspect, but the people who are in the house. In fact, my lord, I also saw the statement of Zandi, who says in that statement, her initial statement, she can identify the second intruder specifically. She's very specific, and we can refer the court to the paragraph where she says this. So to be more precise, my lord, 813 of the disclosure, the discovery that we made, is a statement of Zandi Kumalo. And paragraph 11, it's where she says, she describes the second intruder, and she says she can be able to identify this person if she sees her again. It's paragraph 11, and the statement is 813 in the docket.
And that statement of Ms. Kumalo that you referred to, 813, was made on the 27th of October 2014, correct?
I am not sure about the date, my lord. One will have to, let me just get to it now, my lord, because the docket. Yes, 27 October 2014. That is correct, my lord. At 1400 hours.
And the ID parade, the ID kit compilation, do you know when that happened?
29, it was the 29th of October. That's my understanding. 29th of October 2014.
I-ID kit yona ke yenziwa nge-29th of October 2014.
So a day apart from making her contemporaneous statement whilst the events are still fresh in her mind, a day later, having said in her statement, I can identify the second person, she sits with the sketch artist, yet she cannot even give the barest of descriptions.
I think, my lord, in fairness to Ms. Zandi, that is a terrain that can be, I think, embarked on between with her and Warrant Officer Steenkamp, because I was not there. Because subsequent to this statement, my lord, in other statement that she made, there is nowhere where she had said she has now changed her mind and she can't identify the person.
Just bear with me. I want to see the evidence of Ms. Kumalo on the 19th of July 2023.
Yes.
what she testified about. And it's encapsulated at page 34. It's not a long thing that I'm going to read. Ms. Khumalo says, and it's at line 23, page 34. On the second one, I then mentioned that he was tall, he had a beard, and I added his complexion. And Master Baloyi asked, what was the complexion? She says, he was not light in complexion, he was not dark. That is the evidence in this court. Even this evidence, but like we say, the terrain that I'll argue, it's a generic and a vague description by her. There are no facial identifying features except to state that he's got a beard, he's tall, he was wearing a hoodie, and he was dark, not dark. There are no unique identifying descriptors given by Zandile in her testimony, but that's not for you to answer. I'll argue that point.
Agreed, my lord.
Now, the witnesses that were in the house, now we are at the scene. They describe how this incident happened, that two intruders come in, the one in front is short, is dark, got shiny skin, dots on his face, high cheekbones, dark in complexion, dreadlocks reaching up to the neck level. And I'm doing this deliberately because as they were testifying, they were gesturing by doing this, some of them. And that one is the first one to enter. He is in possession of a firearm. He then demands a second suspect who's much taller than the first one that entered, and they give that generic description that I've just given you.
Correct, my lord.
He was tall, wearing a hoodie, he was dark.
That's correct, my lord.
But what I really want to lead to, that evidence is on record. What is pivotal is that they state that Longwetwala at some stage, after the demand for cell phones and money is made, stands up, confronts the one with the firearm, that is the short one in dreadlocks, pushes him away, and then runs out of the house.
That is correct. I do have a recollection of that, my lord.
Now, I don't want, like I said, to belabor that evidence. It's off record. What I want to know is that, is there a statement or evidence that you are aware of to the effect that when Longwe ran outside, he saw the other perpetrators, that would be the lookouts at the window outside at the yard? Is there a statement to that effect?
No, there isn't.
Now let's go to the point that you said you're going to we're going to verify. Are there statements of witnesses that says we saw people after the first shot or second shot or third shot, whatever shot, run out of Makhumalo's household into the street and going whatever direction that they were going? Is there such a statement?
So, yes, my lord. So the first one that, well, the docket is voluminous. I think the court can see. So I've not exhausted all the searching, but the first one that I could come across that says that exactly is the one of Makaleni. That is A11.
Yes.
And in paragraph 3, he says specifically that he saw 3 black male running away from Khumalo's house. Specifically, he specifies that, and it's A11 in the docket, and that is in paragraph 3.
Okay, and then that one was armed with a firearm. In compilation of this identity kit with Warrant Officer Steenkamp, she says that firearm, he says, or he places that firearm in the hands of the person that is depicted on the left of the picture, according to the descriptor given in the identity kit, correct?
I think let's go there so,
Yeah,
so that I don't say is it A46?
It's I think it's A46.
Yes,
correct,
A46.
Yeah. A46.
I've got it, my lord. I just want to read and make sure that we're on the same page.
I think where he says he was having something in his hands that looked like a firearm.
Yes, that is correct, my lord. It does say witness saw something in his hand that could have been a firearm. That's correct, my lord.
Okay. Now you also testified that from, I think it's the reading of it, and you will correct me because that's a bit fuzzy now in my mind. A statement of Longwetwala that he, after the shots were fired, or the first shot was fired, he then ran back into the house. Correct me if I'm wrong on that aspect.
No, I don't think we went that far insofar as Longwetwala is concerned.
Okay.
We when we dealt with Longwe, it was insofar as his description of the revolver.
Okay. No,
that's how far we went.
No, I recall now. You said you were referring to either HH and JJ when you were speaking about collaboration. Or, I don't know whether that word is collaboration or corroboration, but you said, according to one of those statements, HH and JJ, the accused number 2 says when he was running out after the first shot, another of the co-perpetrators then ran into the house.
Correct.
Yes.
Ngikushilo ukuthi inkathi ke umsolo wesibili ephuma ke noma ukuthi isibhamu sikhumile kokuqala omunye ke yena ke wangena ngaphakathi endlini.
Now, the evidence of Zandile Khumalo on that aspect, and that will be found at page 56 of the transcript of the 18th of July 2023 is to this effect. I'm not going to read that. I'm just going to paraphrase. Is that after the phone from her mother, now that is the S4 phone belonging to Kelly Khumalo, was taken by the intruder with a firearm, that will be the one with dreadlocks. She was in the bathroom and she was fearful. He then ran back into the house. Correct me if I'm wrong on that aspect.
No, I don't think we went that far insofar as Longwetwala is concerned.
Okay.
We when we dealt with Longwe, it was insofar as his description of the revolver. That's how far we went.
No, I recall now. You said you were referring to either HH and JJ when you were speaking about collaboration. I don't know whether that word is collaboration or corroboration, but you said, according to one of those statements, HH and JJ, the accused number 2 says when he was running out after the first shot, another of the co-perpetrators then ran into the house.
Correct.
Yes. Now, the evidence of Zandile Khumalo on that aspect, and that will be found at page 56 of the transcript of the 18th of July 2023 is to this effect. I'm not going to read that. I'm just going to paraphrase. Is that after the phone from her mother, now that is the S4 phone belonging to Kelly Khumalo, was taken by the intruder with a firearm, that will be the one with dreadlocks. She was in the bathroom and she was fearful that perhaps this intruder will come for me. So she peeped through the bathroom door and she saw that after he took the phone, he immediately left. And within seconds, she left the bathroom, the confines of the safety of the bathroom, went to where she saw Senzo running from the kitchen towards the corner of the dining room with Kelly and the mother at the corner, and nobody else came in thereafter.
My lord, I think the difficulty I'll have with with that evidence, I was not in court, so it will be really difficult because I don't know how the question was asked and answered. All I can say, my lord, is that there is evidence in the confessions, or rather it is contained, it is alleged in the confession of accused 2, that when I think the first shot and the second shot that hit the deceased, he ran out. It is contained there. It's not what I'm saying or assuming. And then he said, as he was running out, the one of his co-accused, and he mentions it, my lord, it's also the accused 4 went in, and then he ran into the car where John accused 5, and later he was joined by the other accused. That's what he says, my lord. So that assertion is coming from that angle, my lord. So
as a please, my lord, I think that proposition needs to be put in its proper context. Mr. Ramosele quotes the evidence of Ms. Zandi Kumalo saying from her vantage point in the bathroom where he could see towards the dining room. She did not see any person running into the house, but it should be specified that running towards the dining room could be that the person ran into the kitchen. The way that Mr. Ramosele put it, my lord, doesn't correctly depict the evidence of Ms. Kumalo.
As it pleases my lord, it's quite a simple and crisp answer. In one of her testimonies, Zandile Kumalo says, our house, our kitchen is quite tiny, so you see everywhere. So,
sorry, but she was emerging from a bathroom.
Yes, and
are you saying the bathroom is glass or glazed? Because then I understood the evidence. The bathroom, actually says, was between the basin and the toilet. And when you open, it opens towards the inside.
Yes.
Yeah, I listened to the evidence.
Yes, but remember...
But then,
yes.
Does he say she could see the rest of the house, according to you?
Which door will
the bathroom door? Which opens inside? Which doesn't open outside?
Which door?
Hello?
Which door was used to enter the Kumalo house?
The kitchen door.
Yes.
And the kitchen door, when you enter the house, there are cupboards on the side. You've got to traverse that distance right up to the passage, and then you traverse the distance of the sitting room.
My lord, that's an issue that I will canvass as well when we deal with these exhibits HH and JJs to see the inconsistencies, the contradictions vis-a-vis themselves and the other evidence that was led in this court by witnesses that were in the house.
The evidence that we have of Ms. Kumalo, sorry to interrupt, Mr. Ramosele, on page 56, on the 18th of July 2023, she says, then the gentleman with the dreadlocks took the phone and turned around. I did not know whether he was coming towards or coming to me, and then I went back into the toilet and it closed. And she then said, and then in no time I peeped through again and saw that it means that he did not, or he was not coming towards me, which means that he went out of the door. So, my lord, in other words, she's saying her view was restricted to the corridor. That's her evidence.
Yeah, let's move forward. Now, like I said, Brigadier, I've deliberately left the issue of the so-called confessional statements for the end of my cross-examination, right?
Yes, understood, my lord.
Now let us go to the evidence of Zungu, Constable Zungu, who is central to why the accused persons, and in particular accused number 2, is before court.
Yes, my lord, I'm listening.
Now, in the trial, within the trial, you testified that your informant that led you to now focus your investigation was Constable Zungu, right?
I don't think I classified him as an informer, my lord. I referred to the statement of Absalom Zungu, the father, to say he's the one that gave us the statement. I don't think I referred. I remember when I was cross-examined by Mr. Mgomezulu specific, where he said I relied on informers, and I said no, there was no informers. I relied on the statement by Absalom Zungu.
Brigadier, maybe you will take me to your trial within the trial, whereby you speak about the statement of Absalom Mkantezi Zungu, because for me, for the first time I hear that you relied on the statement of Absalom Zungu to lead you now to focus on accused 1 and 2. Was not during your testimony in chief.
Yes, absolutely. We can go to the records, and that is why, my lord, I'm specific that this issue was canvassed between myself and Mr. Mgomezulu as to what did I rely on, and Mr. Mgomezulu was leaning towards informers, and we debated on that part to an extent where I said there is a statement in the docket which was taken from Absolute Zungu, and he specifically implicates accused 1 and 2. So that is there. I'm certain of it 100%.
And do you know who is the source of Absolute Zungu's information that he provided to you?
Well, my lord, it's clearly depicted in his statement. This is Absolute Zungu, that he witnessed certain discussions, and in those discussions in the homelands, accused 1 and 2 were implicated in this matter, in the killing of Senzo Meyiwa. That's what the statement says.
And before we go any further, is that Absolute Zungu to this day still alive?
Yes, it's still alive. Insofar as I know, it's still alive, my lord.
So in other words, because you say now you relied on Absolute Zungu, but Absolute Zungu was privy to conversation, or was he told by somebody else this information that he then relates to you?
Yes, but like I said, my lord, it's contained in his statement. We can get to it so that we put the correct context of what he says. We have that statement and we've disclosed it to the defense, so we can perhaps go straight to it if we want to put the contents of what he said.
With what we discussed in the morning regarding admissibility of certain evidence provisionally, I'm going to ask that we focus on that statement of Absolute Zungu and that it be admitted provisionally, because I intend to call him and interrogate him regarding that statement that he made.
Yes, my lord. So should I go to it now?
Let's go there. Do we have it, Brigadier?
I'm checking the index.
Oh, okay.
The statement is so good here. When I also assembly. You remember?
Yes.
I
Yes, ma'am.
things in my head.
So
When I also assembly, no state there. You can't remember, fine, no problem.
I remember, that's not that statement, my lord.
No, I'm just saying, is that the same statement?
It's not.
Okay, fine.
My
That's
memory,
fine.
my lord, is very sharp.
Is that so?
Yes. I've got a sharp memory.
Very sharp.
Very sharp.
Your colleague is smiling.
He knows, and he's got a sharp memory as well.
Oh.
So I'm getting to it, my lord. I've got it. I just need to get to it.
So you say you're intending to call
Yes,
Mr. Absalom Zungu,
indeed so, my lord.
okay? And the state doesn't intend calling him.
No, my lord.
Okay, fine, yeah. So in other words, okay, fine.
I've got it. So, no, I have it.
Okay.
I have it. So should I read it into record?
Yeah,
The entire statement.
It's the entire statement. Okay. Yes, sir.
All right. So it says, I, the undersigned Absalom Zungu, with ID number. The ID number is mentioned, my lord. I'm an adult male born on 1958 of 2/14, so it's February the 14th, residing. There's an address given, my lord. I am currently unemployed and temporary work at Pete Retif. The address where he's working as well as the cell phone number is mentioned, my lord. Then paragraph 2, in late 2017, I met Mpekiseni Ntanzi, who is my relative from Homelands in Kwanongoma. I met Mpekiseni in Durban at Kwamashu squatter camp. It was during the general discussion between myself and him, whereby he told me something shocking. He said to me there was once a fight or argument between his brother Mafika Ntanzi and another Ntanzi brother in Sisutu homeland in Kwanongoma. I do not recall what was Mafika arguing with his elder brother about, according to Mpekiseni. Mpekiseni said after the argument, he was told by the other Ntanzi brother that he won't fight with Mafika. Instead, he will rather report him to the police for the murder of a Orlando Pirates goalkeeper called Senzo Meyiwa back in Phosphorus. He further said he was told by the brother of Mafika, not Mpekiseni, that Mafika Ntanzi committed the murder with Muzi Sibia, who is also from Kwanongoma. I further do know that the two mentioned suspects were staying in the hostel in Phosphorus during the time Senzo Meyiwa was killed. I further know that Muzi Sibia had dreadlocks at a certain time but cut them off after the murder of Senzo. Muzi Sibia is currently somewhere in Kwanongoma and Mafika is currently working at a certain mine in Rustenburg. Paragraph 4. I am aware that the two were also used as hitmen and their ringleader was one Nkani Zungu of Sisutu area, Kwanongoma. However, he is currently in jail. I have further identified a photograph of Muzi Sibia to the police and attached it together with this statement marked ANZ1. I was not told by Mpekiseni as to why Muzi Sibia and Mafika killed Senzo. After receiving the above information, I decided to tell my son, who is a police officer in Johannesburg, about the above information. His name is Sikumbuzo Zungu. Subsequent to that, I was then informed by Sikumbuzo that we should go meet the police at head office SAPS in Pretoria. Indeed, the police were met and I disposed the above statement to Colonel Gininda, who was with Sergeant Mukhane. I can identify Mafika to the police if I see him, but I do not have his photos. This is all I can say for now. Then paragraph 5, my lord, is the oath, and then it was commissioned by myself on the 17th of November 2019 at 16:25.
To be exhibit Chaprol U.
Yeah. Okay. What's the place Sosoba?
I can't make out that.
I know a guy called Sosobala.
The traditional healer.
Yes.
The traditional healer, my lord. He was, rather.
Oh, so you do go to a traditional.
No, I just know of him, my lord. He was very famous, so
Yeah.
I just know of him.
I see Mr. Nisi is surprised. I used to play soccer, so there were guys who come in with magical stories. So Sobala was one of the big guys who would come with stories like he can make a ball vanish.
True.
So Sobala.
My lord, I see it's just approaching 3 o'clock.
Is that so?
Yes.
My lord, I think that Ngumalo will be more.
Oh yeah.
Yeah, he'll be more clued up about this, Mr. Sosoban. From the same homeland.
That's not you are from Pietermaritzburg. My name is Nguma. No, Gupi. English? Oh, yo, I'm Okay, should we adjourn then?
Yes, my lord, I would suggest that we adjourn until tomorrow.
What's the time now?
It's 3 o'clock, my lord.
Should we adjourn? Appel in your hands.
Please, man.
Brigadier, speak, even you yourself.
Then we can go up to first if you understood.
Yes?
Let's go up to first, no problem.
Should we go to, my lord, the suggestion on the left is that we adjourn now.
Let's go up to first.
Let's go to
Then see the judge here kick it. Kick it, the judge. Follow my hand.
Okay. Now, Brigadier, from the statement that you have read, I pick up early on that you relied on the information that is hearsay to investigate accused number 1 and 2. The deponent says, I have information from a relative of accused number 2 to the following effect that he mentions there. Then I also inform my son, that's another hearsay, and my son says, we need to go and see the police in Pretoria. That is the gist.
That's correct, my lord. But the son was there. He's the one that came to us. This Kumbuzo Zungu is actually Constable Zungu.
Yes.
And an effort, my lord, was made to find the person who told the father, to collaborate it. And the person was found, but he was scared and fearful of the reprisal because this was a family. These are relatives. So there was a standoff, my lord, in terms of that person giving a statement to corroborate that assertion, my lord, which was not unusual, my lord, because court will remember that when I testify in evidence in chief, Constable Zungu, when he came to bring this information first to say this is what he heard from his father, it was way earlier in the year. And then we made an agreement that he must get his father so that the father can actually be the one coming to tell me this information. He found him months later, I think it's 6 months or so odd, when he was then, where we eventually made an arrangement to meet. We were first supposed to meet on the 12th of November. We shifted it in 2019 to the 13th of November from our side with Brigadier Perumal, and subsequently when we met on the 13th of November, he then said he was able to convince his father to come through, and that's how now on the 17th of November we met for the statement. So, but there was difficulty in getting them to come forward in fearful of reprisal. They made it clear that our life would be in danger. That was the case from this person mentioning, but he did confirm that yes, I did tell my brother, but I'm not going to make a statement. And that also, my lord, to put this into proper context because it affects Zungu, and that is why if one looks at Constable Zungu's statement, it was only taken while this trial actually was in progress. Was it? Yeah, I think it was taken sometime last year, Constable Zungu's statement. And the reason for that, my lord, is that as I was investigating, this is now after having sight of accused 2, 1 and 2, 3, 4 and 5. As we were busy obtaining statements from witnesses, it became apparently clear in terms of the statements that were obtained that on the day of the incident, this is now the 26th of October 2014, at the hostel where the planning took place, Constable Zungu was there, but not as part of the planning as the people who were there for the traditional dance music. So I think I recall 2 statements where his name kept on coming up to say he was there, being mentioned by witnesses. Kwabeni is one of those people. I think Makosenko also mentions him. There's a couple of statements that we obtained, my lord. And it was during that time when I went back to him to say, but your name is being mentioned, what happened? And then he opened up also to say, fearful of being assassinated due to the proximity of the accused, he wanted us to do the investigation, but he opened up, my lord, and said, look, I'll tell you what I know, but there was fear and concern that he might be killed.
And throughout Zungu's testimony, by Zungu I refer to Constable Zungu, he never indicated that his father was the source of the information that he now came and testified about in this court.
My lord, firstly, I was not, obviously the difficulties is, I don't know how the context was put when Constable Zungu was testifying. But these are 2 different reports. The father was telling me about what he witnessed with his relative in KZN, not that he had a direct engagement with the accused. It was a hearsay, as Mr. Ramosele has correctly put it, from a brother, his relative, in trying to manage the dispute in the homeland. So he only made a assertion insofar as that is concerned. Zungu involvement is insofar as what took place at the hostel where the planning was done when he was present. So those, when he was present, and when I confronted him with his name coming up, my lord, as I said, when I said, but why? Because I confronted him, why didn't you bring this information to me from the beginning? The indication with the response was that he was scared. He wanted justice to be done, hence is the one that came forward on his own, my lord, because he came on his own right from the beginning to the office of the National Commission, where I was informed there's a there's a person who has information about the death of Senzo. That came from him in the beginning, but then he introduced the file and kept himself away. But when he was confronted, my lord, he opened up and told the truth. And I may add lastly, my lord, that in matters of this nature, especially where it is alleged that hitmen are involved, it's not an easy thing to get people to cooperate because they know the consequences should they be exposed, my lord, to the hitmen. The consequences are dire. At times people have lost their lives. So when someone says he's fearful of his life, I personally understand because I dealt with such matters, my lord. Yes, my lord.
In line with our agreement yesterday, Brigadier, confine your answers. We've worked in cases where hitmen and people lost their lives. It's unnecessary, you know that.
No, I agree, my lord, but the inference was not to say the accused are hitmen. I was just making a general remark to say when someone...
Let me approach.
Okay. Must I finish? Yeah. When someone make that assertion, and I think in my response, my lord, I was very cautious. I never said the accused before court are hitmen. I made a remark to say in matters that I've dealt with, that I've came across during my career, when people are saying they are scared because there is this allegation that hitmen are involved, I do understand that because I've seen witnesses in other matters really losing their lives in giving information to the police. That's the context I was saying, my lord.
Thank you, my lord, for the indulgence. Now, right at the top, when I said you relied on hearsay evidence to investigate accused number 1 and 2, especially, let's take it with the father's hearsay. The person that you refer to and that the father says he obtained the information from, that Gininda. Early on in my consultation in preparation for this case, I've consulted with him and vehemently he denies ever telling Mr. Absalom Zungu the said information that is deposed in Absalom Zungu's statement. That's the first point. And number 2, he is based in Mpumalanga. He does not know the shacks or whatever place that Mr. Absalom Zungu says he met him in Durban at that period.
My lord, I was not there during the consultation of Mr. Ramosele with this individual. I think if I was part of it, then we could take this discussion further, my lord.
We suppose this person will be called as well.
Yeah. I was coming there. You overshot. The point now that I'm coming to, and this is exactly that point, this witness I'll call and he'll come and testify and tell this court and deny whatever it is said about him in that affidavit of Absalom Zungu.
My lord, like I said, I was not there during that discussion with Mr. Ramosele and the said person, so I can't, I think I rather not, that's the terrain I'd rather stay away because I was not there. All I can rely on is what Mr. Absalom Zungu said and the interaction that I had with the 3 that I've mentioned, my lord.
What's the name of this witness, by the way?
Mbekiseni Ntanzi, my lord.
Mbekiseni?
Yes.
Who?
Ntanzi.
Ntanzi?
Yes.
You say he stays out in...
He's in the
Mpumalanga?
Yes, my lord.
In Zululand. You know, Shaka used to rule this whole subcontinent. Today we say the Zululand in Mpumalanga, fine. That's why it's so strong. Who's this guy? So Shango, the general.
Yes.
He went right up to Zimbabwe. You don't know that?
I did mention in school.
When they say Amashangan,
I don't know.
Abantu Baga Soshangi, is that not so? General?
Yes, Soshangi.
Yeah, after they conquered the people that side, they gave him the idiom of saying Abantu Baga Soshangan.
Yes.
But if you talk to a Tsonga person, he'll tell you that I'm Tsonga, I'm not a Shangan.
Correct.
Is that so, Mr.
Missing a statement, but
I need to say
advocate Baloye and advocate.
No, I'm asking because you're from Mpumalanga, you said, and I'm not saying that.
Yes, I am. But
yeah, fine.
In relation to whether a person is a Tsonga or Shangana, I think the appropriate authorities.
Oh, I see. Okay. Baloye, okay, fine. I hear you.
Thank you, my lord. Now, Constable Zungu, regarding the involvement of his father, he testified the following, and it's also contained in his statement, that when he met you, you were skeptical that he knows the accused that you are referring to, 1 and 2, and that you wanted confirmation that indeed he's related to them, and then you wanted a next of kin to come and confirm that indeed he knows them, and then he opted by bringing his father with. He never mentioned that his father was also privy to some information that was provided to him.
My Lord, I'm sitting with the statement of Mr. Absalom Zungu. I think it speaks for itself. I can't take it further than it. It speaks for itself as to what he's saying to me.
My Lord, at this juncture, since nearly 4:15, the other day I was badly affected by this aircon, and I see it's beginning. So I'd suggest that also the background noise that it makes me scream at the top of my voice, and when I get home, my voice is strained. So I'm going to request that we adjourn until tomorrow.
All right. Have business. Are you available tomorrow?
Yes, I am, my Lord.